rate, it is also payable, and it is also payable at the age of attaining 50 years. And where pensionable service is less than 10 years, the member has an option to remain uncovered for the pensioner benefits till 58 years of age and claim the benefits on a later date with the withdrawal benefits. Now, the scheme provides for the payment of monthly pension in the following contingencies. It can be the superannuation on attaining the age of 58 years, or it can be the retirement, or it can be the permanent total disablement or death during the service, or death after retirement, that is the superannuation or permanent total disablement, or it can be the children pension or the orphan pension. And the amount of monthly pension will vary from member to member depending upon the pensionable salary and the pensionable service. So generally the formula for the calculation of monthly members pension is members pension is equal to pensionable salary into pensionable service plus 2 divided by 70. So here there's an illustration as well. If the contributory service is 33 years and the pensionable salary is 5,000 per month, then the calculation would be pensionable salary 5,000 into the pensionable service 33 plus 2 divided by 70. So which would be 2,500 per month. So wherever the contributory service is less than 20 years but more than 10 years, monthly pension is required to be determined as if the member has rendered eligible service of 20 years. And the amounts hereof shall be reduced at the rate of 3% for every year by which the eligible service falls short of 20 years, subject to the maximum reduction of 25%. So here, the rate of minimum widow pension is rupees 450 per month, and the maximum may go up to rupees 5,000 per month, payable as normal members pension on completion of nearly 33 years of service. So family pension up to 1,750 per month is also payable to the widow of the member who has contributed only for 1 month to the pension fund. In addition to the widow's pension, the family is also entitled to children's pension. The rate of children pension is 25% of widow pension for each child, subject to a minimum of rupees 115 per month per child. And if there are no parents alive, the scheme will provide for orphan pension at 75% of the widow pension payable to orphans, subject to a minimum of rupees 170 per month per orphan. So the above scheme has been amended, making dependent parents eligible for the pension, and further the disabled children are also made eligible for the lifelong pension under the pension scheme. And here the employees have an option to accept the admissible pension or reduced pension with the return of capital. So the case of employees who are opting for 10% less pension than the actual entitlement, the scheme provides for return of capital equivalent to 100 times of the original pension in the event of death of the pensioner. And here there's an illustration as well. If the monthly pension is rupees 2,000 per month and the employees opts for reduced pension of 1,800, the employee will have a refund of the capital amounting to rupees 2 lakhs on the death of the pensioner. In addition, the widow and the two children will continue to get the pension for the lifelong up to the age of, for the life up to the age of 25 years as the case may be. So this is what all the pension scheme says, that the benefit will be provided to the widow, the orphans and the dependent parents. Now, Employees Pension Scheme 1995, which was introduced, which came into being from 16th of November. So the determination of monies from employers is the Central Provident Fund Commissioner, any additional Central Provident Fund Commissioner or any Deputy Provident Fund Commissioner or any Regional Provident Fund Commissioner or any Assistant Provident Fund Commissioner may by order, whenever there is a dispute arises regarding the applicability of the Act to an establishment, decide such dispute and determine the amount due from any employer under any provision of this Act, the scheme or the pension scheme or the insurance scheme, as the case may be, will be conduct an inquiry and try to take the necessary action. Now, Employees Deposit Linked Insurance Scheme, the Act was amended in the year 1976, And a new section 6B was inserted, empowering the central government to frame a scheme to be called the Employees Deposit Linked Insurance Scheme, and for this purpose of providing life insurance benefit to the employees of any establishment or class of establishments to which the Act applies. So the central government has accordingly framed the Employees Deposit Linked Insurance Scheme 1976. It came into force on the 1st of August 1976. Now, coming to the application of the scheme, the Employees Deposit Insurance Scheme 1976 is applicable to all the factories, establishments to which the Employees Provident Funds and the Miscellaneous Provisions Act 1952 applies, and the contributions to the insurance fund. The employees are not required to contribute to the insurance fund. The employers are required to pay the contribution. It is not the employees, but the employers will be contributing the insurance fund at the rate of 1% of the total emoluments. And the employers of all are covered establishments are required to pay charges to the insurance fund at the rate of 0.01% of the pay of the employee members for meeting the administrative charges. So this is subject to a minimum of 2 rupees per month. Now, coming to the nomination can be made by member under the Employee Provident Fund Scheme 1952, and in the Exempted Provident Fund is related as a nomination under this particular scheme. And the payment of assurance benefit in case of death of a member, an amount equal to the average benefit in the amount of the disease during the 12 months or the period of membership, whichever is less, shall be paid to the person. So, in case of average balance exceeds rupees 50,000, the amount payable shall be 50,000 plus 40% of the amount. Such excess subject to a ceiling of rupees 1 lakh. Now, there's an exemption from the scheme as well. The factories and establishments which have an insurance scheme conferring more benefits than those provided under the statutory scheme may be granted exemption. So, if the factory is providing better facilities, better, provisions, better conditions to the employees than the statutory, then it may be exempted from this particular deposit-linked insurance scheme. Now, coming to the appellate tribunal, Employees Provident Funds Appellate Tribunal is dealt under Section 70. So, the central government, by notification in the official gazette, constitute one or more appellate tribunals to be known as Employees Provident Funds Appellate Tribunal, which can exercise the powers and discharge whatever the functions which have been conferred to such tribunal. And every such tribunal shall have the jurisdiction, and this is in respect of the establishment situated wherein such an areas may be specified in the notification constituting the tribunal. So, appeals to the tribunal is dealt under Section 71, subsection 1. So, the agreed person by notification issued by the central government or an order passed by the central government or any authority may prefer to appeal to a tribunal against such notification. Now, there's also interest payable by the employer. So, if an employer is liable to pay simple interest at the rate of 12% per annum or such higher rate, which may be specified in the Employees Provident Fund scheme. And the priority of payment of contribution above other debts whenever the employer is adjudicated or insolvent. So, the priority of the payment will be of the contribution over the other debts or other realizations what the employer has to make. And coming to the next subheading, authorities and their duties in the past. We have the inspectors which have been defined under Section 13. So, the appropriate government by notification in the official gazette may appoint such persons as it thinks fit to be the inspectors for the purpose of this act. And coming to the cognizance of offences under Section 14 AB, anything which has been contained in the Code of Criminal Procedure 1973, an offence relating to default in payment of contribution by an employer is punishable under the Act shall be cognizable. And the power to recover damages under Section 14B are intended to compensate the loss to the beneficiaries of the scheme Damages means it can be any pecuniary reparation due to the loss of or any injury by one person, and this is due to the fault or the negligence of another. So the payment of any contribution to the employee's provident fund or family pension fund or deposit insurance linked insurance fund. So the employer is liable to pay the damages if he commits any default under this. And the transfer of accumulation required to be transferred by him or any payment or charges payable under any provisions of this particular act. So coming to the inquiry, the Central Provident Fund Commissioner or any officer authorized has the power to recover the penalty of such damages, and this can be considering the facts, after considering the facts of each particular case, and if there is any inquiry which is to be required to be done, so that has to be done, and based upon the principles of natural justice should be applied. Now, coming to the power of court to make orders, the liability of an employer convicted of an offense of making default in case of the payment of any contributions to the employee's provident fund or the pension fund or the employee's deposit linked insurance fund, or in the case of transfer of accumulations required to be transferred by him under section 15 subsection 2 or 17 subsection 5, if they does not come to an end by paying damages levied by the authority. So in these cases, the court has the power to intervene and direct the concerned authorities for the case, depending upon the case, the contributions, or it can be the accumulations or the transfer, whatever may be the offense committed. The court may, if it thinks fit, so on the application in that behalf from time to time, so they might extend the period and they might see that the justice is forward to the concerned aggrieved person. Coming to the exemption, the appropriate government may exempt any establishment from the operation of all or any of the provisions of any scheme which has been mentioned in section 17. So earlier also we have seen if the I mean the private industries or maybe the organizations, if they are able to provide the better facilities than the government linked, that is the insurance, then they are exempt from having the deposit linked insurance schemes. So under such cases, the government may intervene and may exempt the organizations which come under that particular criteria. Now, protection of action taken in good faith. So no suit, no prosecution or other legal proceeding shall be lying against the central government or state government or the presiding officer of a tribunal or any authority referred to under section 7A, that if the action has been taken in good faith. So coming to the central government, it has the power to give directions, it has the power to make rules, it has the power to remove difficulties, wherein these are dealt under section 20, 21 and 22. Coming to the schedules of the act, the schedule 1, it deals with the industries to which the act is applicable, and the central government has the power to add any industry to this particular schedule. And coming to the schedule 2, it deals with the matters for which the provision may be in the employees provident fund scheme, or schedule 3, it deals with the matters for which the provisions may be made in the employees pension scheme. Schedule 4, it deals with the matters to be provided in the employees deposit linked insurance scheme. And then we have the Payment of Gratuity Act 1972. Gratuity is a lump sum payment made by the employer as a mark of recognition of the service rendered by the employees, and this is given at the time of leave. That is when the person leaves the organization. So gratuity is the payment which is intended to help an employee after his retirement, as in the case may be, with the provident fund or pension. So it is earned by an employee as a reward for his long service, meritorious service with the organization. So that is the reason why the payment of gratuity is made compulsory, or I mean, not every organization provides. The organizations which apply to the scheme of the Payment of Gratuities Act 1972 will try to stick to it and pay the gratuity. Coming to the objective, it is an act enacted to provide for a scheme for the payment of gratuity to employees who are engaged in the factories of mines, oil fields, plantation, ports, railway companies, shops, or other establishments for the matters connected. So the payment of gratuity is a social security measure and it is envisaged in the directive principles. And the Act also affords some protection in money terms to the industrial workmen or the commercial employees against the risks of retirement or old age. And for the long-term service, for the meritorious service, what they have rendered, for the loyal service, what they have rendered to the employer, to acknowledge such service, the gratuity is paid. And the commencement is from 16 September 1972. The Act came into force and it extends to whole of India. And the Act was applied to only certain establishments prior to its amendment. The gratuity was paid to persons who are covered within the meaning of the term employee under Section 2E of the Act, subject to the conditions mentioned in Section 4 of the Payment of the Gratuities Act 1972. So the Payment of Gratuity Act 1972 applies to the establishments employing 10 or more persons. And coming to the applicability, to an employed person, it always depends upon two factors. Firstly, he should be an employed in an establishment to which the Act applies. And secondly, he should be an employee as defined under Section 2E. So according to Section 1, subsection 3, the Act applies to every factory, mine, oil field, plantations, port and railway company, every shop or establishment within the meaning of any law for the time being in force, and such other establishment or class of establishments in which 10 or more employees are employed or were employed on any day of the preceding 12 months. So in exercise of the past conferred, the central government has specified motor transport undertakings, clubs, chambers of commerce and industry, inland water transport, establishments, solicitor officers, etc. A shop or establishment to which the Act has become applicable once. Now, coming to the definitions, appropriate government means in relation to an establishment belonging to or under the control of the central government, having branches in more than one state, of a factory belonging to or under the control of the central government, or major port, mine, oil field, or railway company, the central government, and in any other case, the state government. So it may be noted that large organizations have branches in more than one state. In such cases, the appropriate government is the central government, and any dispute connected with the payment or non-payment of the gratuity, it falls within the jurisdiction of the controlling authority, or it can be the appellate authority which has been appointed under the central government. So the continuous service, what does the continuous service mean? An employee shall be said to be in continuous service for a period if he has for that period been in an uninterrupted service, including service which may be interrupted on account of sickness or accident or leave or absence from duty, without leave, not being absent, in respect of which an order treating the absence as a break in service which has been passed in accordance with the standing orders. So an employee should be in continuous service, not interrupted or uninterrupted service. So the service can be interrupted. It can be due to sickness, or it can be due to accident. It can be due to leave. It can be absence from duty, without leave. So any of these criteria will be considered from when we are calculating the continuous service. Where an employee, not being an employee employed in a seasonal establishment, is not in continuous service for any period of 1 year or 6 months, he shall be deemed to be in continuous service under the employer. So, for the period of 1 year, if the employee during the period of 12 calendar months preceding the date with reference to which calculations is to be made has actually worked under the employer for not less than 100 and 90 days in case of an employee employed below the ground or in a mine. And in an establishment which works for less than 60 days in a week, 240 days in any other case. So this would be considered as continuous service, 190 days, where the employee is working under the ground, and 240 days in any other case. For the said period of 6 months, if the employee during the period of 6 calendar months preceding the date with reference to which the calculations has to be made actually worked under the employer for not less than 95 days in case of an employee worked under the ground, below the ground, and 125 days in any other case. Okay, so the continuous service will be categorized based on these two calculations. And who is an employee? Employee is a person who has been under Section 2E of the Act, has been amended by the Payment of Gratuity Act. So it covers teachers in the educational institutions retrospectively with effect from 3rd April 1997. The amendment to the definition of employee has been introduced in pursuance to the judgment of the Supreme Court. The ceiling on the amount of the gratuity is from rupees 10 lakhs to 20 lakhs. This has been enhanced by the Payment of Gratuity Amendment Act 2010. So, what does a family mean now? The family is in relation to an employee shall be deemed to consist of, in case of a male employee, himself, his wife, his children, whether married or unmarried, his dependent parents and dependent parents of his wife, the widow and children of any predeceased son, if any. So, a family means spouse, that is the self male, his wife, his dependent parents, wife's dependent parents, his children, whether married or unmarried. If married, the widow and the children of the predeceased son. Okay, so all this comes under the family. In case of a female employee, herself, her husband, her children, whether married or unmarried, her dependent parents and the dependent parents of her husband, and the widow and the children of her predeceased son. So the definition is more or less same. Retirement means termination of the service of an employee otherwise than on superannuation. What is superannuation? It is the attainment by the employee of such age as is fixed in the contract or conditions of the service as the age of attainment of which the employee shall vacate the employment. Now, wages means all emoluments which are earned by an employee while on duty or on leave in accordance. And gratuity payable is nothing but 15 days of wages into number of completed years of service. Part of a year in excess of 6 months shall be counted as 1 year. In case of seasonal establishment, 7 days wages for each season of service completed by the employee is considered for the calculation. Now, the conditions for the payment of gratuity, it can be paid on his superannuation or on his retirement or resignation or on his death or disablement due to accident or disease. So, the gratuity is payable normally to the employee himself. However, in case of a death, it can be paid to the nominee if no nomination has been made to his heirs. Where any such nominee or heirs is a minor, the share of such minor shall be deposited with the controlling authority, who shall invest the same for the benefit of such minor in any bank. Now, the amount of gratuity payable as per the amendment, the ceiling of the gratuity amount from rupees 10 lakhs to 20 lakhs has been amended, and the employee covered by the act is required to make a nomination. And the forfeiture of gratuity, the forfeiture can happen in 2 ways. Provides the gratuity of an employee whose services have been terminated for any act of willful omission or negligence or causing any damage or loss or destruction to the property. Or 46B deals with where the service of an employee have been terminated for righteous or disorderly conduct which has led to an act of violence. Now, exemption of the gratuity, the appropriate government may exempt any factory or establishment covered for any class or classes of the employees from the payment of the gratuity. Now, coming to the obligations of payment of gratuity, it lays down that person who is eligible for the payment of gratuity under the Act he is or any authorized person in writing to act on his behalf shall send a written application to the employer. Rule 7 of the payment of the gratuity rules shall be made in accordance within 30 days of the date of gratuity becomes payable. So the rules also provide that where the date of the superannuation or retirement of an employee is known, the employee may apply to the employer before 30 days of the date of the superannuation or retirement. So a nominee of an employee who is eligible for the payment of the gratuity in case of the death of the employee shall apply to the employee ordinarily within the 30 days from the date of the gratuity becomes payable to him. Now, the employer's duty is to determine the amount and pay gratuity. So, if the Act says that the employer shall arrange the payment of the amount of gratuity within 30 days from the date of it becoming payable, and if it is not paid by the employer within the specified period, he has to pay a 10% interest on such amount. Now, the recovery of the gratuity, Section 8 also provides that if the gratuity payable under the Act is not paid by the employer within the prescribed time, the controlling authority shall, on an application made to it, on his behalf of the aggrieved person, may issue a certificate for that amount to the collector, who shall recover the same from the employer with the compound interest. Now, the protection of the gratuity has been exempted from the attachment in execution of any decree or order of any civil, revenue, or criminal court. So, you cannot attach the gratuity. So, the protection of the gratuity has been taken as a primary concern. And the authorities and their duties and the powers and the procedures, you have the controlling authority, you have the appellate authority, and you have the inspectors. So the appropriate government by notification in the official gazette may appoint an officer to be a controlling authority, and he has the where there is a dispute with regard to the gratuity, the employer or employee or any other person can make an application to the controlling authority for deciding the issue. And we also have appellate authority, and he can be either the appropriate government itself or any other authority. So even they deal with the provisions relating to the gratuity, non-payment of the gratuity. So if there is any appeal, the controlling authority may prefer an appeal to the appellate authority, and within 60 days from the date of the receipt of the order of the controlling authority, it may appeal and could also extend it by further the period of 60 days, and based on the approach, it has the power of being giving an opportunity of being heard. It can confirm, it can modify, or it can reverse the decision of the controlling authority. And we also have the inspectors. So the official gazette or notification can be issued by the appropriate government and appoint the inspectors, and the inspectors require the employer to furnish the information. They have the authority to enter into any premises, examine the employer or the employee. They may make copies or take extracts from the records, and they have the power to search and seize, and every inspector shall be deemed to be a public servant. So under the IPC Code 1860. So coming to the penalties and prosecutions, the purpose of avoiding any payment of the gratuity, if it is proved, a fine that may extend up to 10,000 or the imprisonment up to 6 months can be levied, and an employer who contravenes or making default, it can be from 3 months to 1 year, the imprisonment, or the fine might be extending up to 10,000 to 20,000. And we also have the miscellaneous provisions. The appropriate government has power to exempt. It has the power to recover the gratuity. It has the exemption of employer from the liability, discharge him from the payment. It has the cognizance of offense. It has also the protection of action taken in good faith, and it has the power to protect the gratuity and act. It has the power to make rules. It has act to override the other enactments. It has the power to display the notice and abstract of the act and make rules and implement the rules. So this is what all about the gratuity. And coming to the next is the Contract Labor Regulation and Abolition Act 1970. So what is the Contract Act? Now coming to the Contract Act, Contract Labor Regulation and Abolition Act 1970 and Maternity Benefit Act 1971 are the two important legislations which have been enacted by the Government of India. The Contract Labor Regulation and Abolition Act has been enacted by the Indian legislature in the year 1970. So this act intends to prohibit the employment of contract labor in certain circumstances and to regulate the working conditions of the contract labor during the employment. So the contract labor is a significant part whose growing form of employment. And if you're not protecting him, the employer will try to, when it comes to the working conditions or the payment, so the contract laborers are the people who can be, exploited. So here this act, but particular act has come into the protection, into the aid of protecting the contract labor. Now, coming to the objectives, the major objectives are to mitigate the plight of contract labor, to abolish the malpractices attributed to the contract labor. So, to understanding the difficulties of the contract labor, the plight of the contract labor, and also to abolish if anything is being done, which actually exploits the contract labor. Now, the commencement, it has taken place in the year 1970 and it applies to all the establishments in which 20 or more workmen are employed in the preceding 12 months and to every contractor who employs or employed on any day of the preceding 12 months 20 or more workmen. Now, coming to the applicability, the Act applies to the establishment and the contractor who are employed 20 or more workmen in any of the preceding 12 months. And the Act does not apply to the establishment where work is of a casual nature or it is intermittent in nature, and the work is not considered as intermittent if it was performed for more than 120 days in the preceding 12 months, or if it is a seasonal character and is performed for more than 60 days in a year. So the appropriate government, by giving not less than 2 months notice by notification in the official gazette, may establish or contract employing less than 20 workmen. Now, the appropriate government can be the central government or it can be the state government. A contract labor who has been employed as contract labor in connection with the work of an establishment where he is hired in connection with such work or through a contractor with or without the knowledge of the principal employer. Now, the contractor in relation to an establishment or contractor means a person who undertakes to produce given results for the establishment other than mere supply of goods or articles for the manufacturing to such establishment through contract labor who supplies contract labor for the work or the establishment. So not only the goods or the materials, the contractor will also supply the contract laborers or workers. Controlled industry means an industry, the control of which is by the union, has been declared by the Central Act. Now, an establishment can be any office or department of the government or local authority, any place where any industry, trade, business, manufacture or occupation is carried out. Coming to the principal employer in relation to any office or department of the government or a local authority, it can be the head of the office or the department or the officers. So workman, it means any person who is employed in connection with the work. It can be the managerial or administrative capacity. It can be a supervisory capacity, or it can also be an outwork. Now, the Central Advisory Board, it requires Section 3 requires the central government to constitute a Central Advisory Contract Labor Board, which will be advising the central government on such matters, or it can be the State Advisory Board as well. And coming to the registration of the establishment employing contract labor, appointment of registering officer, Section 6 empowers the appropriate government to appoint by notification in the official gazette a person being a gazette officer for the government, and the registration of certain establishments. Every establishment is covered by the Act. If it wants to engage 20 or more persons through a contractor, must get itself registered under Section 7 of this particular Act. Now, the revocation of the registration, generally a registration fee might be varying from 20 to 500 rupees, which has to be paid by the industry or the establishment which wants to get registered. Now, the revocation of the registration in certain cases, if the registering officer is not satisfied, either it can be the reference made by him or by mere obtained by the misrepresentation or suppression of any material or the fact, that the registration has become useless and becomes ineffective from any other reason, then the registration can be revoked. So what is the effect of non-registration? So Section 9, no principal employer of an establishment to which the Act applies can employ contract labor if he has not obtained a certification of registration, or the certificate has been revoked after being issued. Now, prohibition of employment of contract labor, this is dealt under Section 10. So the appropriate government shall consult the central board or as the case may be, the state board, or the central government shall have regard to the conditions of the work or the benefits which have been provided to the contract labor. So whether the process or the operation, other work incidental, which is necessary for the industry or for the trade or for the business, manufacture or occupation which has been carried out by the establishment, or it can be the perennial nature, that is to say that it is sufficient duration having regard to the nature of the industry, whether it is done ordinarily through regular workmen in that establishment, or whether it is sufficient to apply considerable number of full-time workmen. So based on this, the prohibition of employment of contract labor, Section 10 deals. Now, the appointment of licensing officer and the licensing contractor is empowered under Section 11, which gives the authority to the appropriate government to appoint gazetted officer to be the licensing officers. Now, what is the licensing of contractors? So, under Section 12 of the Act, no contractor to whom the Act applies can undertake or execute or do any other work through contract labor except under in accordance with the license issued to him on behalf of the licensing officer. So the license shall be issued on the payment of prescribed fee and on the deposit of security, whatever may be the case. So the license fee will be ranging generally from rupees 5 to 125 depending upon the number of workmen which have been employed. And this license fee is non-transferable. Now, once the application has been made in the prescribed form and when all the particulars have been referred pertaining to the location, nature, operation of work, it can be for which the contract labor have been employed and so on and so forth, then the license will be issued and generally it is valid for the period specified therein, 12 months under the central rules. Now, revocation, suspension and amendment of the license. So, if the licensing officer is satisfied, either by the reference or either on a reference made or on otherwise or any other category or any other behalf also. So, and if that the license has been obtained by misrepresentation or suppression of any facts, the license might be revoked or suspended, and after submitting the necessary information or the details, it might be also giving the amendments in the license. Now, Section 15 gives the chance for the appeal, where the Act makes provision for appeals against the orders relating to the grant of registration, revocation of the registration, or suspension of the license. So, the aggrieved person within 30 days from the date of the order shall communicate for the appeal, and it will be the appellate officer may entertain an appeal even after the expiry of 30 days if the conditions are so. And then based on the appeal, they will try to give an opportunity of being heard and make such necessary amendments. Now, coming to the welfare and health of a contract labor, now the contractors are required to take certain specific measures. It can be relating to the canteens. So the appropriate government make rules to have power to make rules requiring that in every establishment wherein the contract labor numbering is 100 or more, ordinarily employed by a contractor, and the employment of the contract labor is likely to continue for such period as may be prescribed. One or more canteens shall be provided and maintained. Restrooms in every place where the contract labor is required to halt at night in connection with the work of an establishment. They should be having proper restrooms. Other facilities, it shall be the duty of every contractor employing contract labor provide sufficient supply of wholesome drinking water for the contract labor at convenient places, sufficient urinals or the wash areas, and also the washing facilities, the first aid facilities should also be provided. So liabilities of the principal employer in certain cases, if the prescribed amenities like canteens, restrooms, and other facilities are not provided by the contractor within the prescribed time, then such amenities shall be provided by the principal employer within such time. And all the expenses incurred by the principal employer in providing the amenities may be recovered by him from the contractor. So responsibility for the payment of the wages, it is a common complaint against the contractor that they do not pay proper wages to the contract laborers, or the payments are not made in time. So to take care of such malpractices, the Contract Labor Regulations and the Abolition Act 1970 lays down that the contractor shall pay wages in the presence of the authorized representatives from the employer. Now, authorities and their duties, the registering officer, the appropriate government, or it can be the licensing officers, or it can be the appellate officer, or the inspectors who have been appointed have the power to examine, seize, take oath from the employer and employee and get the material evidences or the facts. Now, coming to the offenses, if any of these things have not been done properly, so we have the offenses by the companies. A company can be any body corporate, it can be a firm or association, or it can be a director relating, who shall be punished under the law for the offenses made by him. Now, the cognizance of an offense, section 26 provides that no court shall take cognizance of any offense under this act except on a complaint made with the previous sanction in writing, and no court inferior to that of the presidency, magistrate, or a magistrate of the first class shall try any offense. Now, coming to the prosecution, section 27 says that limitations of prosecutions, that no court shall take cognizance of an offense punishable under this act unless the complaint thereof is made within the 3 months from the date of such alleged commission of the offense. Now, maintenance of the records and registers, it is the duty of the employer to maintain all the contractor to maintain all the registers and the records which are to be in such form which has been prescribed by the appropriate authority. Now, coming to the liabilities, to register the establishment under the Act, not to employ contract labor when there is no registration. If it is a registration has been done to provide canteens, restrooms, and first aid facilities, to pay wages in full, and then to maintain registers and records. So, what are the offenses? If he is obstructing any inspector, a fine up to rupees 500 and 3 months imprisonment, or both can be given as a penalty. And willful refusal to produce or the demand, whatever the demands, the registers or papers, the documents, what the inspectors have asked, imprisonment up to 3 months or fine up to rupees 500 or both. Any contravention of any provision, imprisonment up to 3 months and fine up to rupees 1,000 or both, and additional fine per day ₹100 for such continuous convictions. So we have the miscellaneous provisions. All the expenses incurred by the employer for the health can be recovered from the contractor. If the commission of the offense is attributable to the neglect of any part of the director or the manager or the managing agent, it shall be deemed to be the guilty as an offense, and no contract labor is precluded from entering into an agreement with the principal employer. In case of an emergency, the appropriate government, by notification in the official gazette and subject to such conditions and the restrictions, direct the provisions of the act or make rules. And the central government has the power to give directions to the government, any state, regarding or execution of the provisions. And if there is any difficulty arising to that effect, the provisions of this act, the central government may, by order published in the official gazette, remove the difficulties. And it has the power to make rules. Now, coming to the application of the other rules, reading the we have by virtue the Payment of Wages Act, by the Industrial Disputes Act, and also the Minimum Wages Act and the Employee State Insurance Act. So all these acts can be governed under the applications of the other laws. Coming to the Maternity Benefit Act 1961, every woman has a right to live with dignity, and it has also said that she has the certain benefits which can be for the complete health maintenance for herself and for the unborn child. So these come under the maternity benefits. So the Convention of the Protection of Motherhood, which has been adopted in 1919 among ILO, based on that specifications in the year 1921, the government of India reported that it was not possible to adopt the convention passed in the year 1919, and due to various reasons, a bill was brought before the Central Legislative Assembly by a private member in 1924, urging the government to make it compulsory for the employers to provide maternity benefits to women. Now, the commencement of the act in relation to the mines and any other establishments wherein the persons are employed for the exhibition, acrobatic and other performances by the central government, and in relation to the other establishments in a state by the state government. It is applicable to every establishment, being a factory or a mine or a plantation, including any such establishment belonging to the government, wherein the persons are employed for the exhibition of equestrian, acrobatic, and other performances. Now, coming to the definitions, they remain the same. The appropriate government can be the central government or it can be the state government. A child includes a stillborn child. Commissioning mother means a biological mother who uses her egg to create an embryo implanted in any other woman. Employer, in relation to an establishment which is under the control of the government, a person or authority appointed by the government in relation to an establishment or under any local authority, the person appointed by such authority for the supervision, and in any other case, the person who the authority which has the ultimate control. Now, what is an establishment? It means a factory, a mine, a plantation, a shop. And what is the maternity benefit? It means any payment referring to the subsection 1, section 5. Wages means all the remuneration paid or payable in cash to a woman, and such allowances which can be DNS allowance, HRA, and it can be the incentive bonus, the money value of the any concessional supply of food grains or other articles, but does not include any bonus or any other incentive bonus, overtime earnings, or any contribution made, paid or payable to the employer to any pension fund. Woman means a woman employed whether directly or through any agency for the wages. Miscarriages, the definition of the miscarriages is similar to the definition as given in the section 2 of the Employees State Insurance Act. So, employment or work by women prohibited during certain periods. So, section 4 of the Act provides that no employer shall knowingly employ a woman in any establishment employ a woman in any establishment during the 6 weeks immediately following the day of her delivery, miscarriage, or medical termination of pregnancy. It also specifies that no woman shall work in any establishment during the 6 weeks immediately following the day of her delivery, miscarriage, or medical termination of pregnancy. Right to payment of maternity benefits. Every woman shall be entitled by her employer, and the employer is liable for the payment of maternity benefit at the rate of the average daily wage for the period of her actual absence. And the average daily wage means here the average of the woman's wages payable to her for the day on which she has worked during the period of the 3 calendar months immediately preceding the date from which she absence. So a woman shall be entitled to maternity benefit if she has actually worked in any establishment of the employer from whom she can claim the maternity benefit. So what is the maximum period for which any woman shall be entitled to maternity benefit shall be 26 weeks, of which not more than 8 weeks shall precede the date of her expected delivery. However, the maximum period can be taking 2 or more than 2 surviving children shall be 12 weeks, of which not more than 6 weeks shall precede the date of her expected delivery. So, a woman who legally adopts a child below the age of 3 months or a commissioning mother shall be entitled to a maternity benefit for a period of 12 weeks from the date the child has been handed over or adopted or the commissioning of the mother has taken place. So, notice of claim for maternity benefit. Section 6 deals with the notice of the claim of the maternity benefit and the payment thereof. As per the section, any woman employed in any establishment is entitled for the maternity benefit under the provisions. In case of a woman who is pregnant, such notice shall state the date from which she will be absent from work and not being a date earlier than 6 weeks from the date of her expected delivery. And payment of maternity benefit in case of a death of a woman. If a woman is entitled to a maternity benefit or any other amount under this act, dies before receiving such maternity benefit, the employer is liable for the to pay the maternity benefit under the second proviso of subsection 3 of section 5. He will pay such amount to the person nominated by the woman in the notice given under section 6. Payment of medical bonus. Every woman is entitled to maternity benefit under this act shall also be entitled to receive from her employer a medical bonus of 1,000 rupees if no prenatal confinement or postnatal care is provided by the employer free of charge. Now, there is also leave for miscarriage. In case of a miscarriage or medical termination of pregnancy, a woman shall, on production of such proof as may be prescribed, is entitled to a leave with wages at the right of maternity benefit for a period of 6 weeks immediately following the day of her miscarriage. Leave with wages for tubectomy operation, any family planning operation, if the woman is taking, then the production of such proof, she may be entitled for a leave, paid leave at the rate of maternity benefit for a period of 2 weeks immediately following the day of her tubectomy operation. A woman suffering from illness arising out of pregnancy, delivery, premature birth, miscarriage, medical termination, in all such cases, the leave with wages for a maternity period for a maximum period of 1 month is provided. Work from home option from 26 weeks leave period. After the expiry of that leave period, depending upon the nature of the work, the woman can avail work from home option as well. Nursing breaks. Every woman delivered of a child who returns to their duty after such delivery, in addition to the interval for the rest allowed to her, she also has 2 breaks of the prescribed duration for nursing the child until the child attains the age of 15 months. So we also have crash breaks. Every establishment having 50 or more employees shall have the facility of a crash within such distance as prescribed, and a woman can during her intervals she has at least 4 visits she can make to the crash. And forfeiture of the maternity benefit, if a woman works in any establishment after she has been permitted by her employer to absent herself under the provision 6 for a period during such authorized absence, he shall forfeit her claim of the maternity benefit for such period. So dismissal during absence or pregnancy, when a woman is absent herself from the work in accordance with the provisions of this act, and the discharge or dismissal of any woman at the time of her pregnancy. And if the woman, but for a discharge or dismissal, would have been entitled for a maternity benefit or medical bonus referred to in section 8 shall not have the effect of depriving her of the maternity benefit or bonus. And any woman deprived of maternity benefit or medical bonus or both, or discharged or dismissed during the account of her absence from work, so within 60 days from the date on which the order of such deprivation or discharge or dismissal is communicated to her, an appeal can be made to the appropriate authority for which the discharge or dismissal action can be taken. No deduction from the normal or usual daily wages of a woman are entitled to a maternity benefit. And the government, the appropriate government with the notification in the official gazette may appoint inspectors who are going to define the provisions as per the act. And coming to the penalties, if the employer contravenes any rules made under the Maternity Benefit Act, he may be imprisoned for a period of 1 year and also a fine of 5,000 rupees or both. And the amendment of Act 69 of 1951, there was an amendment. And the Plantations Labor Act 1951, the letter of, the sickness, and after the word sickness allowance and clause B shall be omitted. And this is the amendment what they have made in subsection 2, the words or maternity shall be omitted. So on the application of this act to the Mines and Mines Maternity Benefit Act 1941 and the factories situated in the Union Territory of Delhi and Bombay, the Maternity Benefit Act 1921. So coming to the amendments to the Maternity Benefit Act, increase the maternity benefit from 12 weeks to 26 weeks for 2 surviving children, 12 weeks for more than 2 children, 12 weeks maternity benefit to a commissioning mother, adopting mother, facilitate work from home, providing mandatory crashes where the employee is having more than 50. So this is how the maternity benefit has been, the act has been provided to safeguard the interest of the women employees working in the organization. Now, the last block is the contemporary issues where we have the child labor and the sexual harassment and the information technology. So coming to the child labor, this is dealt under the Child Labor Prohibition and Regulation Act 1986. So this we are going to see in tomorrow's class. As of now, it is already 2:30, so I stopped sharing. We'll continue from this chapter. So, I guess no doubts. Any doubts?
No, ma'am.
Okay, ma'am. So tomorrow we'll try to complete these 3 concepts. Tomorrow being the last day, we'll try to finish. And if time permits, we'll discuss the important concepts as well.
Okay, ma'am. Thank you, ma'am.